Okay, let's jump right into this explainer. If you've ever watched a property dispute unfold, you know it gets incredibly messy and fast. Emotions run high, people panic, and the stress is just off the charts. But the absolute biggest mistake people make in these situations isn't a lack of deep legal knowledge, it's relying on their emotions instead of the hard evidence. Before we can intelligently argue about a foreclosure, a title dispute, or a family estate, we have to understand one fundamental, unbreakable rule. The record comes before the remedy.
Now, what's really fascinating here is the shift in mindset. Look, human nature makes us want to guess. When we're stressed out, we guess who truly owns a property, we guess if a bank's foreclosure is legally defective, or we kind of just guess if a random lien is enforceable based on, something we read online at 2 in the morning. We want a quick fix. But the law, it doesn't train us to guess, and the courts for sure don't reward it. You simply cannot jump straight to a powerful legal remedy without checking the foundational facts first. What the law actually requires us to do is verify.
Think of it like trying to build this massive, beautiful house without even bothering to check if the foundation you're building on is solid concrete or sinking sand. You literally cannot argue your case until you lay down the foundation of the public record. A legal remedy without a factual record is, well, it's just guesswork, and guesswork loses in court. The record is the only thing that tells us exactly what property is involved, who actually holds the title, what liens genuinely exist, and what documents are officially recorded with the county.
So, let's move to our first major section here, the legal battlefield, where claims become visible.
Real property law is overwhelmingly record-heavy. We're talking about massive, chaotic stacks of county land records, mortgages, promissory notes, tax liens, the whole shebang. Honestly, sometimes just walking into a county clerk's office feels like stepping into a paper hurricane. But there is a crucial reason for all of this paperwork. Just one missing assignment in a mortgage file or one unreleased lien can completely flip the outcome of a case. This proves exactly why skipping the paperwork and guessing is just a recipe for total disaster. While simply recording a document doesn't automatically make it legally bulletproof, the legal record is where all these competing claims finally become visible to the court.
That brings us to Section 2, Why Guessing Fails, Emotion versus the Record.
It's so incredibly common to feel a deep personal attachment to a home, right? You might stand on your front porch, look around at where you've raised your family, and say with absolute conviction, that is my house. And morally, emotionally, you might be 100% right. But the cold, hard county land records, they don't care about your memories there. The record will strictly ask, okay, but who legally holds the title right now? It immediately disciplines the conversation, stripping away the emotion and forcing us to look at the verifiable facts.
And here's a trap so many people fall into. They proudly declare, oh, I put my property in a trust, and they just assume they're completely legally protected from that moment on. But the record is going to brutally ask if the property was ever actually deeded and legally recorded into that specific trust. A trust doesn't own real estate just because someone says it does, or because they jotted it down on a notepad. There has to be a valid conveyance, an actual deed executed and recorded transferring it to the trust.
Also, when things get stressful, like the threat of losing a home, people understandably get angry. They shout, "Foreclosure fraud," but a judge isn't going to listen to shouting. The record demands specifics. It asks, which required step was violated? You have to methodically verify the paperwork. Was a mandatory default notice missing? Was the completely wrong party foreclosing? Was an assignment defective on a specific date? You have to identify the specific, verifiable defect.
It's the exact same deal with family estates. When an owner passes away, property rights don't just magically transfer because the family believes they should. A family's moral claim or verbal promise means absolutely nothing legally until the record shows that probate was actually opened. Plus, someone must officially hold legal letters of authority, which is basically the court's official permission slip allowing a specific person to manage and transfer the estate's property.
All right, let's look at Section 3, Core Concepts and Missing Pieces, Building the Title Story.
To establish legal ownership, you have to verify what the Cornell Legal Information Institute calls the chain of title. This is the historical record of ownership transfers for a specific property. Think of it like a literal physical chain. By tracing it backward from who owns it right now, all the way to the original owner, you spot the weak links. If even one link from 20 years ago is a forged deed, an unreleased mortgage, or a break in the transfer history, everything attached to it after that point just falls apart.
Mapping out your legal strategy means matching your issue to the exact corresponding record.
Every single problem demands a specific, verifiable piece of proof. Fighting a foreclosure, you need to verify the notices, notes, and assignments. Dealing with a tax lien, you don't defeat it with anger, you pull the record to find the exact recording date in the authorizing law. That is how you determine your actual, viable challenge path.
Which leads us perfectly into Section 4, the Property Record Inventory, the ultimate strategic weapon.
Before you even think about drafting a demand letter or filing a motion in court, you have to aggressively ask yourself, what verifiable documents do we actually have in our hands? Not what did someone on a forum say, not what legal remedies sounds the most intimidating. What actual signatures and county recordings do we have right here, right now?
To do this right, we need to walk through a sequential thought process. First, identify the property and record owner. Second, identify all recorded instruments and liens. Third, and honestly, this is often the massive aha moment in any strategy. Figure out exactly what documents are missing and what deadlines are looming. Discovering what you don't have is just as critical as knowing what you do have. Finally, identify the procedural posture.
Now, I know meticulously cataloging documents in a property record inventory sounds like the most boring administrative busywork imaginable, but I want to be absolutely clear. It is not busywork. It is the absolute prerequisite to winning. Building this inventory trains you to organize a complex property issue entirely around undeniable facts before you ever start jumping to legal conclusions.
Let's hit Section 5, Missing Pieces and Posture. Timing determines remedy.
Once your inventory is totally complete, you have to determine your procedural posture. This is critical because your available remedies shift drastically depending on where you are on the timeline. If you're in the pre-foreclosure default stage, your options might be getting an emergency injunction. That's a completely different world than if the sale has already happened. If you try to file a post-sale eviction defense when you're only in the pre-foreclosure stage, you're going to be laughed out of court. The timeline dictates what's legally possible.
And we come right back to this powerful mantra from the source material. No record, no remedy. It doesn't mean a perfect legal remedy doesn't exist out there somewhere in the universe. It just means you cannot unlock it or effectively use it until you secure the record. Skipping the hard work of building the record isn't practicing legal strategy. It's just guessing in the dark.
Guessing with property doesn't just cost people an argument. It costs them their homes, their generational equity, and their peace of mind. The fake legal shortcuts you see online want you to jump straight to a powerful-sounding remedy without any proof. But the real law, the law that actually works in a courtroom, makes you slow down and verify. So, I'll leave you with this to consider today. Are you actually building a legal strategy, or are you just guessing with your property? Get your records in order, build that inventory, and then, only then, demand your remedy.